Defendant is charged with second-degree murder, MCL 750.317. A preliminary examination was conducted on October 27th and 28th, 2022. Following the presentation of proofs by both parties, the people moved the court to bind defendant over on the single charge of second-degree murder. The relevant underlying factual background is not in dispute. On April 4, 2022, defendant Christopher Schurr was a police officer with the Grand Rapids Police Department on duty and on assignment patrolling the city's southeast side. Just after 8 a.m., defendant initiated the traffic stop of a Nissan Altima after observing that the license plate on the vehicle was issued to another car. Before defendant fully exited the police cruiser, the driver of the Nissan, who was later identified as Patrick Lyoya, stepped out of the Nissan. Defendant shouted at him several times to get back in the vehicle, and Lyoya did not comply. Defendant asked him if he spoke English, to which Lyoya responded yes. Defendant asked Lyoya if he had a driver's license. Lyoya indicated that he did and told the passenger in the Nissan to hand him the license. Lyoya did not wait for the passenger to hand him the license. Instead, Lyoya abruptly closed the door of the vehicle and walked towards the front of the car in what appeared to be an attempt to get away from the officer. Defendant responded by telling Lyoya to stop and reached out to restrain and handcuff him. Defendant was unable to immediately restrain Lyoya, and after a struggle, Lyoya was able to break free from defendant and ran around the back of the Nissan into the adjacent residential front yard. Defendant pursued Lyoya, yelling at him to stop, and is heard radioing out, quote, "We've got one running," close quote. Defendant reached Lyoya on the side yard of the neighboring house. Defendant was able to grab him from behind. While this prevented him from running, defendant struggled to fully restrain and take control of Lyoya. Defendant continued to yell commands at Lyoya to, quote, "stop," and to put his hands behind his back. While Lyoya said, "okay," he continued to struggle and was not complying with the officer's commands. Defendant is seen striking Lyoya's abdomen with a knee multiple times with no apparent effect on Lyoya. Lyoya appears completely impervious to and unaffected by the officer's attempts to subdue and restrain him. By this time, the homeowner in the adjacent house, Wayne Butler, came outside to observe what was occurring. Butler testified that he didn't want to see anyone get hurt, and so he felt compelled to plead with Lyoya to follow the officer's orders, saying, quote, "Come on, bro. I came down for your own safety, man. Come on, comply with him," close quote. Butler testified that he was also encouraging Lyoya's passenger to tell Lyoya to comply and get on the ground. Defendant then pulled his taser from his utility belt. Lyoya grabbed the front of the taser with his left hand. Defendant immediately commanded Lyoya to, quote, "let go of the taser," close quote. Lyoya did not comply. The taser discharged one of its two cartridges, which lodged in the ground without striking anyone. The two continued to struggle over the taser. Defendant and Lyoya struggled to the ground with Lyoya underneath defendant attempting to take exclusive control of the taser. During the struggle, the taser's second cartridge was discharged. Lyoya attempted to get up, raising his legs and arms in an apparent attempt to throw defendant off of his back. At one point, defendant's arms and legs are seen fully suspended in the air as Lyoya pushed up from beneath him. Ultimately, Lyoya gained exclusive control of the handle of the taser and was able to transfer it to his other hand. All the while this went on, defendant continued to shout the commands, quote, "drop the taser," close quote, and, quote, "let go of the taser." Being unable to retain any control of the taser and with Lyoya continuing to attempt to force himself up, defendant used his right hand to draw his service firearm and aimed it at Lyoya's head. Defendant then straightened his left arm while keeping the gun in his right hand, pointed it at Lyoya's head. Defendant yelled one final time, quote, "drop the taser," close quote. Seconds later, defendant fired his weapon, shooting Patrick Lyoya in the head. The Kent County Medical Examiner, Dr. Stephen Cole, testified as to his opinion that Patrick Lyoya's death was homicide caused by a gunshot wound to the back of the head. This court also heard the testimony of Brian Childs, a representative of the manufacturer of the taser. He explained that the taser involved here contained 2 cartridges capable of projecting electrical probes up to about 20 feet. If the probes on the cartridges made contact with a person, they will deliver electrical energy that will cause the person temporary neuromuscular incapacitation, or quote, NMI. A person struck with the probes is rendered completely unable to move for around 5 seconds. He explained that once both cartridges have been deployed, the base or handle of the taser is still capable of delivering a drive stun. The drive stun delivers localized pain to the part of the body touching the front of the taser. However, a drive stun does not result in NMI. Once ejected, the probes can be retrieved and reactivated. However, unless the probe has made sufficient contact with a person, or unless the conductive material on the wire has been exposed as a result of damage to the wire, the taser is only capable of delivering the more benign drive stun that will not result in NMI. The court also heard from Captain Chad McCursey of the Grand Rapids Police Department. Captain McCursey trains police officers and is certified as a master taser instructor. He opined that defendant followed policy and procedure in this case, and that use of deadly force was justified under the totality of the circumstances. He explained the criteria that is considered when evaluating questions concerning the use of force. He also cautioned about the importance of evaluating questions from the circumstances as they appeared to the officer and not with the benefit of hindsight. He also testified that a number of alternative techniques and responses were available to defendant, but that the policy recognizes the discretion the police officer has to make those decisions in the heat of the moment. Captain McCursey offered an example of other tools and techniques that were available to defendant at the time of the incident, including pepper spray or the use of the flashlight, baton, or radio to strike the suspect. He explained that even in using the firearm, an officer is taught that they may aim at different parts of the body depending on the level of force that is necessary. He also indicated that it is impossible to know whether Lyoya simply intended to break the grasp of the officer or to actually affirmatively attack him. Ultimately, Captain McCursey is of the opinion that the defendant followed his training and policy based on what the totality of the circumstances required. After hearing counsel's arguments, the court took this matter under advisement to review the testimony and law in greater detail. Moving on to the analysis of the opinion. It is of primary importance to understand the limited scope of this court's authority and task as it presides over a preliminary examination. In Michigan, the preliminary examination serves the public policy of ceasing judicial proceedings where there is a lack of evidence that a crime was committed or that the defendant committed it. Recognizing the risk associated with standing trial for a felony, the preliminary examination, like the grand jury process, serves as a check on the power of the executive branch of government to proceed with a criminal prosecution. The grand jury has been described historically has been described as the protective bulwark standing solidly between the ordinary citizen and an overzealous prosecutor. And that is from the U.S. Supreme Court case of the United States versus Dioncio, 410 U.S. 1, 1973. However, the scope of judicial review of a criminal prosecution at the preliminary examination is very limited. The judicial officer at the preliminary examination is tasked with making the legal determination of whether there exists the minimal amount of evidence the law requires to justify continuing the criminal prosecution. While the court makes that legal determination independent of the prosecutor's decision to bring criminal charges, the court is prohibited from second-guessing the prosecutor's charging decision. Rather, If the magistrate determines that probable cause exists to support the charge under the law, he is obligated to bind the defendant over for trial. A failure by the court to bind the defendant over in that instance would amount to nothing less than the court's unconstitutional usurpation of power otherwise belonging exclusively to the executive branch of government, and more specifically to the county prosecutor. Stated more plainly, while the court operates as a check on the prosecutor's power to bring criminal charges, it is a very limited check. A court does not have the authority to veto the prosecutor's charging decision in the same way that the governor or president can veto a bill passed by the legislature proposing a law or policy that the governor or president does not like, does not think will work, or does not think is fair. A court can only determine whether the charge is founded upon probable cause. If it is legally sound, the court cannot stand in the way of the criminal prosecution, regardless of what the court might think about the prosecutor's decision to bring charges, or even the likelihood of conviction by a jury. In other words, the limited question for this court is whether the criminal prosecution can continue as a matter of law without any regard for whether the prosecution should proceed based on anything other than the law. At a preliminary examination, a court is tasked with determining whether a felony was committed and whether there is probable cause to believe the defendant committed it. Probable cause exists where the evidence is sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. The evidentiary standard is far less rigorous than that required for a conviction following a trial. And I'll read here from the case of People versus Yost, which is a Michigan Supreme Court case from 2003. At the examination, evidence from which at least an inference may be drawn establishing the elements of the crime charged must be presented. The probable cause standard of proof is, of course, less rigorous than the guilt beyond a reasonable doubt standard of proof. Probable cause requires a quantum of evidence sufficient to cause a person of ordinary prudence and caution to conscientiously entertain a reasonable belief of the accused's guilt. Yet, to find probable cause, a magistrate need not be without doubts regarding guilt. The reason is that the gap between probable cause and guilt beyond a reasonable doubt is broad, and finding guilt beyond a reasonable doubt is the province of the jury. In order to establish that a crime has been committed, the prosecution need not prove each element beyond a reasonable doubt, but must present some evidence of each element. And probable cause may be established purely by circumstantial evidence and reasonable inferences arising from the evidence. During the preliminary examination, the magistrate is not only the right, but also the duty to pass judgment not only on the weight and competency of the evidence, but also on the credibility of the witnesses. However, the court is not to apply the same measure as a jury because of the differences in the standard for bindover and for ultimate guilt. Again, reading from the Supreme Court's opinion in People versus Yost, the Supreme Court explained, the gap between probable cause and guilt beyond a reasonable doubt is broad. And therefore, unlike a jury, a magistrate may legitimately find probable cause while personally entertaining some reservations regarding guilt. Accordingly, in considering credibility of witnesses, a magistrate may only decline to bind over a defendant if a witness's lack of credibility, when considered together with the other evidence presented during the examination, would preclude a person of ordinary prudence and caution from conscientiously entertaining a reasonable belief of the accused's guilt. Indeed, the magistrate or judge may very well be left with reasonable doubt the defendant committed the crime charged, and yet at the same time find probable cause to bind over a defendant on that charge. Moving on to the elements of the charged offense here. The elements of second-degree murder are, number one, a death. Number two, caused by an act of the defendant. Number three, with malice. Number four, without justification or excuse. As a necessary element of second-degree murder, malice reflects the principle that criminal culpability must be tied to the actor's state of mind. Malice is defined as the intent to kill, the intent to cause great bodily harm, or the intent to do an act in wanton and willful disregard of the likelihood that the natural tendency of such behavior is to cause death or great bodily harm. Second-degree murder is a general intent crime and does not require a finding of specific intent or harm to kill. The intent to do an act in obvious disregard of life-endangering consequences is a malicious intent. There is no real question here concerning the first three elements of the charged crime. There is little doubt that Lyola's death was caused by the gunshot wound to the head inflicted by defendant. The clear depiction of the incident in the video strongly infers that defendant knew he was pointing the gun and firing it at close range to Lyola's head, which in turn is sufficient to establish probable cause to conclude that defendant acted with malice. The only real debatable question here is whether defendant's actions were justified under the law. A person is not guilty of a crime even though the person committed the illegal act if a legally recognized justification is factually supportable. At trial, the prosecution has the burden of disproving justification beyond a reasonable doubt once evidence is introduced. For purposes of bind-over, the court must determine whether there is evidence that is sufficient to cause a person of ordinary prudence and caution to consciously entertain a reasonable belief that the homicide of Patrick Lyoya was not justified under the law. Defendant presents three theories that he argues establishes clear justification as a matter of law such that no probable cause exists for bind-over. Number one, that he used force reasonably necessary in defense of himself or others. Number two, that he used appropriate force in response to force used by Lyoya to avoid arrest. And three, that he used reasonable force to prevent a felon from fleeing to avoid capture. We'll begin with the theory of justification by self-defense. While modified by statute in certain respects in recent years, Michigan law governing self-defense remains primarily a creature of common law. At common law, a claim of self-defense, which is founded upon necessity, real or apparent, may be raised by a non-aggressor as a legal justification for an otherwise intentional homicide. The ultimate question requires a factual determination of whether the accused, under all circumstances of the assault, as it appeared to him, honestly believed that he was in danger of losing his life or of great bodily harm, and that it was necessary to do what he did in order to save himself from such apparent threatened danger. Thus, the homicide of Patrick Lyoya would be justified under the law of self-defense only if the defendant honestly and reasonably believed his life was in imminent danger or that there was a threat of serious bodily harm and that it was necessary to exercise deadly force to prevent such harm to himself. Our Supreme Court made it clear that, quote, the touchstone of any claim of self-defense as a justification for homicide is necessity. And indeed, the court confirmed that generally questions concerning the existence or lack of reasonableness or necessity in resorting to deadly force in self-defense are for the jury to decide after considering all of the circumstances. Some conclusions concerning the use of deadly force for self-defense can be made as a matter of law. For example, the general rule under the common law was that a person first attempt to retreat and avoid the danger before being justified in using deadly force in self-defense. However, by operation of law, both common law and more recently by statute, the duty to retreat is completely excused under certain circumstances. For purposes of this case, there is no dispute that defendant was legally pursuing Patrick Lyoya and was therefore legally on the front lawn of a private residence at the point of the shooting. Therefore, under Michigan law, MCL 780.972, defendant did not have any obligation to retreat rather than use force. Nonetheless, factual questions remain as to whether defendant reasonably believed that his life was in imminent danger or that he was in an imminent danger of suffering great bodily harm, and that deadly force was reasonably necessary. These are questions of fact that the jury must decide based on the totality of the circumstances as presented by the evidence at a trial. And indeed, our jury instructions recognize that the ultimate determination of reasonableness and necessity are questions for the jury to decide based on all of the circumstances. Among the standard jury instructions that would likely be read at trial, the jury would be instructed. And I'm going to read from the jury instructions here. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all of the circumstances. And then in parenthetical, the condition of the people involved, including the relative strength, whether the other person was armed with a dangerous weapon or had other means of injuring the defendant, the nature of the other person's attack or threat, whether the defendant knew about any previous violent acts or threats made by the other person. And at the time, the defendant must have honestly and reasonably believed that what he did was immediately necessary. Under the law, a person may only use as much force as he thinks is necessary at the time to protect himself. And when you decide whether the amount of force used seemed to be necessary, you may consider whether the defendant knew about any other ways of protecting himself. But you may also consider how the excitement of the moment affected the choice the defendant made. And that's the end of the quote from the Michigan Standard Criminal Jury Instructions. While defendant has made strong arguments that the circumstances establish reasonableness and necessity, this court cannot make that determination here at the preliminary examination as a matter of law. The evidentiary record from the preliminary examination contains enough to allow a person of average intelligence to conclude that defendant's fear was not reasonable or that the defendant's shooting of Lyoya in the back of the head was not reasonably necessary. Captain McCursey testified that it's not clear to him whether Patrick Lyoya was merely trying to get away or was prepared to offensively attack defendant. Captain McCursey also recounted a number of examples of alternative techniques that may have been available to defendant. Based on the testimony, the threat or danger that the taser presented may not be the same, depending on whether it was only capable of delivering a drive stun at the time that the shot was fired without resulting in NMI. And it is not clear whether defendant knew or should have known that both the taser's cartridges had been discharged. These are all circumstances that might affect how a fact finder would assess the necessity question. While the captain is of the opinion that the techniques and actions defendant applied were appropriate, a juror would be free to conclude that under the circumstances, the use of deadly force in the what manner it was used by defendant was not reasonably necessary. Importantly, the court does not raise these examples to suggest that defendant's actions exceeded what was reasonably necessary. To be clear, this court expresses no opinion on that matter or the ultimate guilt or innocence of defendant. As explained previously, that is not the question before this court. The law recognizes that law enforcement officers are required to make split-second decisions of life and death in dangerous and strenuous circumstances. The reasonableness of those actions can hardly be fully and fairly judged by one person in a black robe with 20/20 vision of hindsight and from the comfortable and safe vantage point of the high perch of the armored plated judge's bench. It is precisely, though, for this reason that questions of reasonableness and all questions of fact are determined by a jury after a full and fair trial. Accordingly, For purposes of the probable cause standard, there is sufficient evidence from which a jury could conclude that defendant did not reasonably believe that his life was immediately at risk, or could otherwise conclude that the use of the particular force used was not reasonably necessary. Moving on then to the second theory of justification, force in response to force used by a person being arrested. Defendant's remaining two theories of justification concern the use of force in making an arrest of a suspected criminal. Defendant points out that the defense in that context can be divided into two categories: the use of deadly force when a person making the arrest is met with force from the person arrested, and secondly, the use of deadly force when necessary to prevent the person who is to be arrested from fleeing. The first category, however, is not a distinct theory of justification from that of self-defense. Rather, it is sometimes highlighted as its own theory because it always excuses any obligation to retreat. Therefore, for the purposes of this case, the theory is completely duplicative and indistinct from the justification of self-defense. As the court already indicated, under Michigan statutory law, the defendant did not have a duty to retreat before resorting to deadly force. And for the same reasons discussed, for purposes of the probable cause standard, there is some evidence from which a jury could conclude the defendant's belief was not reasonable or that his response was not reasonably necessary. The most complex of the three defenses raised is the so-called fleeing felon rule, which under certain circumstances justifies the use of deadly force to prevent a felon from escaping arrest. The complexity is not in its application. To the contrary, if applicable in its purest form, the rule is as draconian and unforgiving as it sounds. Blackstone, the famous English commentator on the common law, observes, quote, "Any private person and any peace officer may arrest a fleeing felon, and if they kill him, provided he cannot otherwise be taken, it is justifiable," close quote. And in 1985, the United States Supreme Court observed that Michigan was only one of 4 states that still followed the rule. And according to one commentator, today Michigan is the only state that continues to follow the rule in its purest common law form. Instead, defendants suggest that there's a lack of complete clarity as to some aspects of the rule under Michigan law. While the rule has been subject to calls for legislative reform for the past 30 years, that has not occurred. Importantly, this court's task and the extent of any court's authority is the determination of what the law actually is, not what anyone else, well, not what it or anyone else thinks the law ought to be. As a matter of public policy, reasonable minds can disagree about the extent to which police officers should be free to make judgment calls without the potential for incurring criminal culpability. This court must simply find what the law is now with any consideration of how it might be changed in one way or another. The 1990 Michigan Supreme Court case of People v. Couch controls the question of what the law is in Michigan today. And while there may be nuances that remain, the primary components are readily discernible and are, at least for purposes of making the probable cause determination required here, more than clear. Under Couch, the common law fleeing felon defense, as it existed in 1846 at the time that the crimes of murder and manslaughter were codified in the state's first penal code, continues to be the governing law of this state. Under that common law fleeing felon rule, the use of deadly force is justified if, number 1, evidence shows that a felony actually occurred. Number 2, the fleeing suspect against whom force was used was the person who committed the felony. And 3, the use of deadly force was necessary to ensure the apprehension of the felon. For purposes of the questions before us today, it is clear that even under this broad and rather forgiving rule of justification, the question of necessity remains tightly wound around its core, requiring an answer to the question of whether the actions of the police officer were reasonably necessary under the circumstances to ensure the apprehension of the felon. And no different than the necessity component at the core of self-defense, necessity to ensure the apprehension of the felon is a question of fact for the jury to decide. In applying the probable cause standard, there is at least some evidence from which a person of average intelligence could conclude that defendant's shooting of Lyoya in the back of the head was not reasonably necessary to prevent his escape. As the prosecutor suggests, at the instant that the shot was fired, Lyoya is not in a position of actively escaping or fleeing. A reasonable juror could find a lack of necessity for deadly force strictly for the purpose of preventing escape. Therefore, for the foregoing reasons, the court concludes that as a matter of law, probable cause has been presented to support the charge in the criminal complaint. Accordingly, it is the court's legal obligation to bind defendant over to the 17th Circuit Court to stand trial on that charge.